And we're back after a legislative half hour. That's on me this time. So we have with us a trio of attorneys from Legislative Council. Abby, do you want to join us first? Abby and Shepard and Michelle Child will be our special guest stars. Abby, we're going to go around the table very quickly. So if you want to know us from our bill requests, now you have a face to scowl at and stay up late. Representative Tom Stevens from Waterbury.
Kathleen James, Bennington 4.
Claudia Lamont, Morristown.
Joe Parsons, Groton Thompson, and Newberry.
Emily Krasnow, Chittenden 9 South Burlington.
Ashley Bartley, Fairfax, and most of Georgia.
Caleb Elder, Starksboro.
Dennis Labonte, Linden, Sutton, Newark, Sheffield, Wheelock.
Hi, I'm Elizabeth Burrows, and I represent Heartland, West Windsor, and Windsor.
And I'm Larry Labor, Essex, Orleans 1.
I'm Mary Howard, and I represent Rutland City District 6.
And Robin Chestnut Tangerman, Rutland Bennington District.
Thank you.
So welcome. Did Damien prime you? I know why you're here.
Good job. Thank you. And thank you for that. I have some of your faces are familiar and I've worked with you in the past, but many of you, this is probably the first time I've seen you.
Yes. What committee do you usually sit in?
So I work on tax matters, personal income and property tax and some of the consumption taxes. So I'm mainly in Ways and Means, which is one of the ways that I know Representative Elder.
So we asked you, because when Damien was doing his walkthrough, he did mention that when we were talking about taxes, how they're considered, taxable income, how it's considered, he did say that you were the subject expert on it and that we should talk to you. So we just wanted to get a clarification of any of the elements. So there's several different topics, I guess. There's the creation of the payroll tax. There's the collection of the payroll tax. There's the potential refund of the payroll tax for people who make $25,000 or less. And then of course, there's the idea of 100% wage replacement versus, how does that work with taxable income versus untaxable income, workers' comp versus UI. So if that's all in whatever's in your bailiwick, that would be kind of what we're interested in hearing about.
Great. Okay. Yes, those are all certainly within personal income tax. And I have prepared a more broad overview of how income tax withholding and estimated payments work to sort of set the stage and hopefully create a structure for you to think about this within the existing law and looking at the way the bill as introduced intersects with withholding and estimated payments. And those are the questions that Damien kindly forwarded on to me. But if you have other questions and I'm not able to answer them immediately, I would be happy to come back or do a little more research. So to start, my sort of big picture that I was hoping to impart to you is that I'm really looking at this as two different types of payments and two different ways in which withholding and estimated payments come into play. So you have both the payment of the tax of the withholding, of the tax that would be going to the state from the individual for the benefit program, thinking of that as a contribution. And the way that the bill is structured currently would follow all of the withholding and estimated payments that are required under income tax law. So you have first that payment from the individual to the state, but you also will have the receipt of the benefit, which is a different, that's sort of a different bucket, which would be considered income. So in that case, you would also have withholding applying in the way that UI is subject to income tax and personal income tax is withheld on those payments. So I just wanted to start by making sure those two separate types of payments are clear in everyone's mind and how that would be intersecting with income tax law as it exists.
Yeah, sorry, I just want to make sure I understood what you just said. There's the payroll contribution, and then for an individual who's receiving the benefits, that is taxable income.
That would be considered taxable income. Okay. That's correct. And yes.
And every category of leave, that was the question. So like we have individual leave for oneself, but also family and medical leave and in years past, we've been told that there's an element of this income that may be untaxed, if it's like workers' comp or UI, I don't know which one it is, so.
Yes, so thank you for that clarification, and I will need to go back, and I'm looking at Damien, sorry, because I know this has come up in the past. And I had not prepared that particular question to address today, but I will, because I know there is IRS guidance on this, because it's workers' comp and UI that are occasionally treated differently.
Yeah, actually, I can pull up my notes on that.
Okay.
Sorry, I was doing something else and not paying attention. I just got caught by the teacher.
Sorry. Threw you under the bus.
I feel like that time in law school when my professor came up behind my laptop and saw that I was like writing an email and then called on me. Sorry, that was on the record, but I'll pull up the notes I have on that from a few years ago.
Thank you.
And so that's important just because we want to have that understanding of, and it doesn't matter whether the wage replacement ends up being 100% or 80% or 60%. It's still the quality of the payments that we just want to understand. Because it seems like if they're getting 100% or any percent, but 100% of wage replacement and it's treated like workers' comp,
Right.
they're gonna still be liable for something later on, I guess.
So my focus has typically been on UI, so unemployment compensation as being treated as taxable income. So that's where I need to go back and do some more research into wage replacement versus receiving income in the form of a benefit, which would be taxable income. And that is my assumption, the way that this bill is drafted, but that could perhaps use some clarity. And I can work with Damien on that if that's necessary. That said,
Representative Chestnut Tangeman.
So on top of page 18, it says that the benefits paid out are exempt from liens and garnishing and that sort of thing. And any other remedy provided for recovery or collection of debt. Is that standard, or is that something unique to this in your experience?
That's sort of different. I'm not sure what that was modeled on. I actually was focusing more on step D, but
I got you.
Damien's paying attention.
So I'm gonna reset and let you just please present what you prepared for. And I'm sorry we're peppering you with.
That's why it's great to be in the room, so I can hear the tenor of your questions. And I definitely will look more into the UI versus workers' comp tax treatment. That's already a great distinction. So the sort of general framework that I wanted to present to you is how withholding currently works and estimated payments work. So I think a lot of your questions were focused on self-employed individuals as well. So withholding is generally required for income tax for wage income, pensions, certain annuities, and other payments. In Vermont, what we call piggyback on federal law. So if it's required federally to withhold, Vermont will withhold income tax. And it's calculated using sort of the same withholding charts. Vermont has its own withholding tables and wage bracket charts. So, we're all in tax filing season right now. So you're probably familiar with seeing some of those charts. Withholding happens at the employer level when it's wages. So a taxpayer, like if we're taking the employer example, the taxpayer or employee will tell their employer how much to withhold on each paycheck. And then there's no transmission of data from the taxpayer to the department. This is purely between the employee and the employer who's withholding the tax. And the employer is under statute technically liable to collect and remit that tax to the department. So there is that interaction, but there's never the employee says, tax department, this is what I'm withholding from my paycheck. It's really between the employer and the employee. That's why sometimes it's referred to as the withholding tax. It's actually income tax, but there's that trustee relationship where the employer is facilitating the payment of the employee's taxes. So that's more in the wage area. Then you have self-employed individuals who are paying estimated income tax. So I'm not talking about self-employment tax. That's another separate issue, but we're just with income tax. Self-employed are required to make estimated payments generally on their earnings. And there are two different ways that those can be made. And under Vermont statute, again, it piggybacks on estimated payment requirements federally. So typically that's a quarterly, every 4-month basis that individuals have to remit. And then there are a few that hopefully answer some of the questions you had about self-employed. There are some safe harbors where underpayments of estimated tax won't be subject to penalties or interest. So there are two different ways that underpayments, if you don't pay exactly your full tax liability, you won't be hit with penalties or interest. So one is when you pay 90% of the current year's tax liability or 100% of the preceding tax year's liability. Additionally, if there is no tax owed, or if the tax owed in the taxable year is less than $500, no penalties or interest will be owed. So I think there was one question about what about self-employed who had no income in the prior year? They would fall under that safe harbor. They would still need to remit. If they're remitting annually as well at the federal level, they can remit annually in Vermont. There's also an option to pay quarterly. So that's the extent of the sort of big picture. And then I had understood you were concerned about, so maybe there are any questions about that sort of big picture, how income tax is paid. Those are the two main streams for remitting. And then of course, individuals reconcile right around now each year.
There's a clause in the bill that talks about or that just sort of infers that an individual can be both self-employed and an employee. And I guess there might be a question, and again, if it's not answerable today, this, if I'm self-employed and I'm making these quarterly payments or annual payments in advance in order to qualify, I guess, I'm sorry, I'm going to answer my own question. I will have signed a 3-year into the program. If I'm trying to access this through my self-employedness, I will have signed up and said I'm going to do this for 3 years, as opposed to if I'm employed for 20 hours or whatever a week, and I'm going to have the money taken out. I guess there's an interplay there that maybe I'm not sure what the taxable results of that would be, but again, I think the answer first is if I'm self-employed, I will have signed up and committed to 3 years.
Correct. And my understanding of the bill is that if you are self-employed and you're not receiving wage income that you would have income tax withheld from, then it's on the self-employed individual to remit on the estimated payment schedule.
Okay.
So there is language that pulls in all of the income tax subchapters relating to withholding and estimated payments. So any of those general rules would apply when making payments under this payroll tax.
Okay, great.
And then I think there was another question about, just pull up the list. Clarifying if employees who work for an employer with a private plan, whether or not they're exempt from withholding. And I'm not sure if that was, so I'm again distinguishing between making the payments and receiving a benefit. So I would like to go back and do more research on how this would potentially be characterized, if it would be more like workers' comp or UI, whether that would automatically be considered taxable income or not. But if it were considered taxable income and you did want to exempt up to a certain portion, or I'm not sure what the discussion has been here, but you would need to include explicit language exempting it from income tax. But again, that would only apply in Vermont, of course,
right.
Not federally.
So Damien, if I can just asking a question on whether it's taxable or not.
Yeah.
If the employee pays anything into, if they pay their 50%, and the employer pays 50%, then what's considered taxable income is in fact taxable. And then, but if the employee pays all of it, is there an exemption of any kind, or do they still have to pay?
Are you talking about income tax on the benefits? Or?
Yes.
Okay, so the way it works, based on my understanding of the IRS rulings in relation to the other states that have this, is for family care leave, so bonding or caring for a family member. It is taxable income under federal tax law. The employee's contributions are deductible. So if the employee pays that 50% contribution, whatever that dollar amount is, could be taken as a deduction if they itemize. But it is taxable. The own disability portion of the insurance, so the families leave for their own serious health condition, is not taxable. It's treated the same as workers' compensation benefits. However, New Jersey is a state where they split 50-50 between the employer and the employee or something like that on the medical leave. So under New Jersey's model, the own disability portion is taxable on the employer's portion of the benefit, 50%, and not taxable on the employee's portion. And it's subject to FICA on the employer's portion, but not on the employee's, because it's treated as an employer disability policy. So it gets complicated. If it was all employee contribution, that would be tax-free, no FICA, no federal income tax, but the family care portion would still be taxable with contributions deductible. So it really depends on whether you keep the split between employers and employees, and that's going to affect the way things shake out. It'll be taxable for any employers who decide to take cover the full contribution for their employees, and it'll be partially taxable if it's just a 50-50 split. And that's the information that I have dating back a couple of years. So Abby and I can check to make sure that hasn't updated, but I don't think it has at this point. So I found a 2020 summary from the outside consultant did it for another state, and I think it lines up with that still, so.
Okay. Clear as mud for everybody? I think
I'll send you this.
so grateful we're not the Ways and Means Committee. Okay. More?
That is the extent of what I prepared. I did just want to point out that there are a few sections that address that withholding applies to the payment of the tax or the contribution. So that's in the new section 2054 of Title 21, and then the payment of benefits and the explicit language saying that individuals should be advised that their benefits may be subject to withholding. That's in the new section 2058.
Okay.
And I'll be happy to go back and delve into that question a little bit more. And if you have other questions, feel free to reach out to me. And I'll be working with Damien on this more.
So just before you go, and Damien, and you can chime in too, just to be clear, when we say in this proposal, we say 100% wage replacement. And so given that there could be, depending on what it's for, it could be treated like a paycheck where there's going to be taxes taken out, and I'm going to receive, instead of $1,000, I'm going to receive $720 or whatever. That's actually going to be closer to my paycheck than it's just going to be closer to my paycheck. Then it's not, I'm not going to get a check for 100% unless it's some workers' comp style situation.
Yes, so those I think are the details to be ironed out, and we'll go.
All right, so we're talking the difference between gross and net. On 100%, it's 100% gross wage replacement, and then the net will net out with the taxes and things. So that's
And so is the same true if it were, there were states that had 60% wage replacement. That's also taxable income. So it's 60% would be gross and you'd get something less than that.
Yep.
I'm looking to Damien because I haven't looked into the.
Yeah, that's my understanding. So the last time I presented on this was when the 3 active programs were California, New Jersey, and Rhode Island. California and Rhode Island had 100% employee contribution. New Jersey split it for medical leave and then was employee funded for bonding leave or parental leave, just to make things really simple. And across the board, caring for family, whether it was bonding or a family member who was sick, was taxable, but you could deduct the employee portion of the contributions. Caring for or taking time off for your own medical condition was not taxable provided the employer hadn't contributed anything to that. If the employer contributed, it was that portion of the overall benefit was taxable, and there was potentially FICA on it as well. So that's your Social Security, your federal Social Security and Medicare tax, which comes out to 7.5%. Is that right, Abby?
Something like that.
Don't know off the top of my head.
So in other words, if I was getting $1,000 back of personal leave and the employer had paid 50% of my premium, it wouldn't be $720. It might be $840 because they're just taxing half of the benefit.
Yes.
Okay.
Yeah, so the taxes could get a little funny with the withholding and so forth on that, but it's, in general, it's gonna be taxable income, I think is the takeaway.
Yeah.
In most situations, you'll owe tax on at least a portion of your benefit.
Yeah. Okay. All right. Well, thank you so much for making our heads hurt a little bit here, but this is exactly why we needed you to come in, is to explain this a little bit. And so if you can come up with something over the next few days over, your non-existent free time on some of the other questions, we would appreciate it.
Absolutely. Thank
Great.
you.
Thanks, Abby.
Thank you.
Thanks.
All right, next up, Michelle, would you like to join us? And we went around the room once, so we're gonna go around the room.
Okay, thank you very much.
Representative Tom Stevens from Waterbury.
Representative Claudia Lamont from Morristown.
Joe Parsons, Groton, Topsom, and Newbury.
Emily Krasnow, South Burlington.
Ashley Bartley, Fairfax and Georgia.
Caleb Elder, the Addison 4 District.
Dennis Labana, Caledonia 3.
I'm Elizabeth Burrows, Windsor 1, Heartland, West Windsor, and Windsor.
Larry Labor, Essex, Orleans, District 1.
Mary Howard, Rutland District 6.
Robin Chestnut Tangerman, Rutland Bennington District.
Nice to meet all the new folks. And I'm Michelle Childs of Legislative Council, and I'm usually across the hall. And part of my portfolio is family law, including and as well as domestic and sexual violence. And I've been here about 25 years working on the judiciary issues. So I don't know much about paid family leave, but I'm happy to answer any questions you have about how that may intersect with criminal law and family law.
Yeah, so the last section of the bill is asking to create a new section called safe leave.
Mm-hmm.
And
you can look at it.
The issues that we were just looking for some explanations about like what, and if anybody can remember also why we asked Damien to talk about this section, please chime in, because I think we're, in a case like domestic violence, there's so many bits and pieces of how it works in the judiciary. What we're trying to do is to create a plan where an individual who needs leave can actually qualify up to 12 weeks. I think I read this correctly, committee, up to 12 weeks in addition to what's in the, if they qualify under Family Medical Leave Act, it's possible they may not qualify under the existing Family Medical Leave Act due to the size of the employer. But this plan for safe leave defines an employer as a plus, as a, like if there's one employee, which is different from the PFLA.
Right.
And it's for job protection purposes. It's not specifically for the insurance portion, though it could be.
Right.
So I'm just curious to know, I think, a little bit about what happens.
Sure. So maybe it'll help if I just give you a little bit of a lay of the land of, with regard to the intersection of domestic and sexual violence with the court system. So there's both a civil and a criminal process with regard to those offenses. So in terms of civil, we're talking about civil protection orders, and Title 15 is your family law title, and there's a chapter on abuse prevention, and there's a process there where someone can go to the court and ask for a protective order, and it applies to people who are family or household members, and household members, it's defined rather broadly in that chapter to include maybe members really of your household who you live with, or it could be someone who you are dating or have dated in the past. It could be someone who you've had a sexual relationship with, things like that. So that's currently defined in law. And so you're able to go and you have to meet a civil standard in order to get a protection order. So civil standard is different from the criminal standard. So civil is preponderance of the evidence. And if you meet the criteria under the chapter, the court can issue, first they have a process where you can get an emergency order. And so those are things that are available any time of day. So if there's a domestic assault or situation and someone needs a protection order and, on the weekend or the middle of the night, there's always court personnel that's available that can respond to that. And the court will issue a temporary order. Those temporary orders are only in effect for 14 days. And that's because those orders are done ex parte, meaning that the defendant isn't given notice or opportunity to be heard at the issuance of that emergency order, because the idea is that you want to protect the person and then everybody come together in court and hear everybody. And so those are only temporary. There's that process. And then after the 14 days, if they want to continue on and receive a final order, then the person would appear and would request a final order. And then the court can issue the order with any types of conditions, such as, to stay away from the plaintiff or the plaintiff's children, to stay a certain distance away from the plaintiff, not to things like that. And those protection orders will commonly be for a year or so. People can extend those orders, but it's really what it is just a restraint on the liberty of the defendant in terms of their contact with the plaintiff. And so that's a civil process. There's also the criminal route, and that's in Title 13. And so we have a subchapter on domestic assault, and there's various offenses under there. And that would be if someone was cited or arrested for a criminal offense of domestic assault, and then they would go through the criminal division, and the criminal division would deal with that case. So sometimes there is both a civil proceeding and a criminal proceeding happening at the same time. Sometimes there's only the civil proceeding, and people feel as though I don't need, I'm not interested in going the criminal route. I just want to know that I just want this person to leave me alone. Sometimes there might just be the criminal route and there's not a civil protection order. So they work independently, but they also can work together. And then with regard to sexual assault and stalking, it's the same kind of setup. So there is a civil process in Title 12. The difference there is that you don't have to be family or household members there because you could have been a survivor of a domestic of sexual assault or stalking and not be a family member or someone who you've dated. But you can get a protection order under Title 12 if you have been sexually assaulted or stalked by someone, and then you can get a protection order against them. And then there are similarly provisions in Title 13 that allow for criminal prosecution of those acts. And again, they can be independent. You can have one without the other, but you could also have both. So that's the kind of court process there. But I will note that as I was looking at the definitions, the definitions that are in H66 refer back to the terms that are used in the Safe at Home program that's run by the Secretary of State's office. And that is an address confidentiality program whereby if someone is a survivor of domestic assault or sexual violence or stalking, they can apply through a procedure to the Secretary of State's office to essentially have kind of like a private address where they can receive mail and things like that. Like if they feel as though they need that for their protection, they can do that. And they've been running that program for several years. And that definition, I will read to you, is a little different because there are obviously definitions of sexual assault and stalking throughout the criminal title and also in the protection orders. But with regard to this references, this is using the definitions in subchapter 3 of the abuse prevention chapter, just dealing with the address confidentiality program. And so if you look at the definition for domestic violence as well as sexual assault and stalking, is they have the qualifier there for participation in the program. It uses the reference to the criminal definition, but it also includes a threat of the acts, regardless of whether the acts or threats have been reported to law enforcement officers. And so there does not necessarily have to have been a police report or an application for an abuse prevention order or a finding of probable cause in front of the court with regard to a criminal offense. So this is employing the same kind of standard that the address confidentiality program is having.
And is there any, currently now, is there any kind of protections? Our committee had a guest star bill a few years ago about providing job protection leave for victims of alleged crimes or alleged victims of crimes. And that had not existed before. And I'm just curious for victims or survivors of DV, are there allowances and job protection allowances in law already of any kind that you're aware of that would kind of inform us on this kind of leave? I mean, I'm assuming that there's not.
Yeah, I that would be a Damien question. I'm sorry to be in our little silos, but I don't know anything about employment law. But I don't know.
Yes.
On page 46 of the bill, there's a number of ways that an employee can verify that they're a victim. Is this range of options typical? There's a self-certification under.
I know under federal law, there's a process for self-certification. And I would have to follow up on that. But, these seem to make sense to me in the sense that So on line 5, on page 46, where you say you have something from the court or law enforcement or other government agency. So if someone did have a protective order, they could supply a copy of that order. If there was a police report, they could submit that as information. But there may be various reasons why it could be, as using the definitions, it might not have been reported to police. They may not have sought a protective order, or maybe they have an order and they don't really want the information that's in the order, the disclosure of private information shared with their employer. So it might be that they don't want the person to necessarily know who they have the protective order against or things like that. And so I presume that that's, part and why you have the other options here. One question I had was whether or not, when it says an employer may require an employee to provide documentation of the need from one of the following, I had just a question about, is it that they can pick anything from there, or is it that, is it up to the employer to decide, or can the person offer, what they want?
Who gets to choose which?
Right. I guess I was just wondering, is it employers like, I need something from the court or I need something from law enforcement, and the person is like, well, I would just like to give you a note from my therapist as I'm receiving treatment for trauma related to this experience or something like that. So I just had a question there about that, but.
Yeah, we received testimony on that from Kara Casey from the Vermont Network, and she had also suggested that we change that language because it does imply, as written, that the employer gets to choose.
I just wasn't clear. I mean, I think you could probably read it either way. I just wasn't sure about the language.
The suggestion was that an employee may provide one of the following. Was the suggestion that was made.
Right.
To change the language, which, considering that you brought that up, would make sense in my head as well.
You can choose, it's policy decision for you, but it's, I would say to maybe clarify if.
Yeah. Thank you for keeping that note. Representative Krasnow?
Yeah, I was just reviewing my notes from when we had that presentation, and I had a similar question to Vice Chair. But yeah, so I guess Damien's back now, but I was just curious, trying to think, in your experience, and you probably have a lot of experience in this, I guess in the workforce, how that works. It seems hard, like more difficult. I don't even know if that's probably. It seems harder for folks who are experiencing those things to be able to talk about that with their employers, and if there's any other examples where this has been used before, the labor force, or if there's, and then you get into the thing about mental health, is there, confidentiality and other HIPAA and.
Right. So again, I'm sorry, I don't know anything about employment law, but I think you're correct. And if you heard from the network, I'm sure you heard them talk about, obviously these are very private emotional issues. And so it's going to really vary depending on the person about what they feel comfortable sharing with their employer. And so I think, if you're, I think having a list where there's a variety of options, so it's not just tied to something from law enforcement or from a court order, is probably important. But I'm sorry, I lost my train of thought.
No, that's good. I know I'm so glad that this is in here, and I just want to make sure that the language is as appropriate and accessible to people who are.
I think, and I think with regard to the medical records, it seems as though they have the ability to just state, this person is a patient, is receiving, they don't have to give any personal protected medical information or anything like that. I think it sounds as though it's saying you just have to have something from your provider stating that you're receiving treatment for them.
And for stalking, would that also, would that be different, a different,
No,
right?
anybody who's receiving counseling for any of these particular offenses would qualify.
I have a note here, probably from the same testimony, but I didn't say who. Asking about, this is a policy question, but having a third party be able to communicate on behalf of the employee as opposed to the employee asking directly for safe leave. I'm wondering your thoughts on that, or if you know examples of that.
Nothing necessarily comes to mind, but I think you're right. It's just going to be a policy decision, and in terms of you want to make sure you put the safeguards in there to ensure that whether it's the self-certification document or whatever those things that, and it's truly the intent of the employee and that person is representing them.
It's so interesting to me that, we've been talking about silos a little bit, and just the silo between what you've been focusing on for your work with the judiciary, that it hasn't included housing or job protection, or, it's just interesting to see or to hear you acknowledge that, that the focus of judiciary kind of stayed in its place, and what we've worked on, and this is trying to cross over and just make, it's a different section of law, but it's just, it's just a different facet of the same stuff. And just interesting to hear.
Right. And I'm sure probably when the network testified, they talked to you about, these types of cases are, because of the nature of them, because they often involve family members or people who they're close with and things. There's not always a police report. There's not always a request for a protection order or pursuing a criminal charge, or even if they are initiated, oftentimes they're dropped for various reasons. And so I assume that that's why using the language that's in the Safe at Home program rather than using the statutory citations to the actual criminal offenses.
Right. Again, this is about, this bill is primarily about job protection. It's being able to give someone who has experienced this the opportunity to seek out, and to give them the tools to seek out healthcare, or having to move, or whatever the subsections are here.
So you might, with regard to the documentation and things like that, it might be helpful to hear from Lauren Hibbert or someone at the Secretary of State's office around the administration of the safe. I don't want to add to your workload, but since they work with those definitions currently, and those are qualifiers to being able to be on their address protection program, it might be helpful if you want more information about how they're certifying that information.
Sure. Any further questions for Michelle right now?
Okay, thanks for having me in.
Thank you.
Thanks.
Thank you, Michelle.
Sure.
Just remember, you got to take a left out of here.
Actually, I'm probably just walking right across the street. Thanks.
Thank you.
All right, Damien.
So could I follow up on one of those questions
No break.
before I forgot? Oh, I don't want to take away a break.
No, that's fine. We can I'll take it off at the end of the day.
Okay. So there was a question about what happens with records when you request a leave. And these records would have to be handled the same way as records related to a request for an accommodation under the Americans with Disabilities Act or Family and Medical Leave Act. So any medical information, employers are required to keep it in a separate personnel file, separate from the personnel file. And it's required to be kept confidential to the extent it's protected under HIPAA or another one of those laws. So employers are already dealing with this. To be fair, I think a lot of small employers may struggle with some of these requirements, not because there's any bad intent, but just simply because there are a lot of requirements, and it gets complicated. So, but yeah, this would be treated the same way if the employers had guidance on it or reviewed guidance. They'd see recommendations that anything like disclosure from a therapist or a physician that provided medical information or a medical diagnosis or information to of that sort would need to be kept separate. And in the same way that if you were requesting leave for 6 weeks for your own medical condition, you can't have something that discloses an illness or a disease in a file that could be accessed by people who are not supposed to have access to that information. So.
Yes, Representative Chris.
And does that include then among the workplace not discussing why the person's gone?
Oh, yeah, I mean, so with that, so a manager or an HR person, except to the extent necessary to administer the leave internally, is not supposed to be discussing that with other staff. So, I mean, in some cases, it's discussions would even omit details if they're not necessary. It depends on the organization, but you're basically looking at, like, you can't just go around to everyone and be like, so-and-so is, receiving counseling for something, and, whether we're talking an incident of domestic violence or a nervous breakdown or substance use disorder or treatment for a disease, that's all information that your supervisor and your HR department are not supposed to share with anyone who doesn't need to know. So,
Okay. Thanks.
yeah.
That's why we say stepping down to spend more time with their family.
Yep.
So what else did we have for you specifically? Follow up on, do you recall? Oh, of course you should recall because you're here.
There's pressure.
Or maybe you're writing an email.
Yeah, I was gonna say, you do have, I have been having a traditional House General week in that every 20 minutes I switch topics. So,
how's it feel? Well, then let me just, do you remember if you have anything specific? Cause I'm not
yeah, I'm just
sure.
gonna flip through to see here if I have any notes. Abby answered that one. I don't think I have specific questions here. I know there were some areas where there were recommended changes that I see in here. And yeah, I'm just seeing recommended changes in my notes here, and then the only question I had in there was answered by Abby.
Sure.
But I'm happy to take questions or return to areas that the committee wanted more detail on.
Representative Bartley.
One question I had is, we know that there's going to be a group of people who are paying into this program who aren't going to benefit from it, or they would just at a lesser rate than their normal pay, their higher wage. Would they have the opportunity to pay extra into the program? Can they say, I would kind of like an IRA?
Not under the way the program's currently designed. So there is the potential that employers could provide additional benefits. But the way the program's currently designed is there's a fixed rate that individuals pay in. And then wage replacement is 100% up to that cap. And after that, the cap applies regardless of how much you earn. Once you get above that cap, you could earn $1,000 more or $100,000 more. You'll get the same benefit, but you will have paid in different amounts.
Okay, and then that fixed rate, and I just want to make sure I'm understanding. February 1st brought to.
Not sure.
Yes, February 1st is where the division brings what their annual request is on the.
Yes, okay, I'm sorry. The fixed rate is when by February 1st, the division would come to the General Assembly with their rate for the next year. General Assembly would then review it, take testimony, and presumably would pass it. And it would go into effect for the coming fiscal year, which starts July 1.
Can I ask
Sure.
questions?
Yeah.
Isn't normally like a taxation rate, isn't that usually the executive branch's function?
So actually, we set the tax rates in statute.
Okay.
So that language for the annual adjustment is based on the workers' compensation administrative fund surcharge, which is a percentage paid on all workers' comp policies.
Okay.
And then there are other ways to set the tax. The unemployment insurance system has a multi-tiered tax rate that depends on the health of the trust fund. And then income taxes are set based on the numbers there, but then the executive branch executes.
Okay.
And in the case of workers' comp, they come back every year with expert testimony to say the fund is okay, or we need more or less.
Would there ever be a cap on an increase? Has there ever been a cap? And could we?
There are states that have caps. Connecticut is an example of a state where the adjustment within a certain range, and I'm going from memory here, but I believe the way Connecticut has set it up is that their administration is allowed to adjust the rate from year to year. But if it hits a certain amount, it triggers an automatic, I think it triggers a reduction in benefits and a return to the legislature, for the legislature to take action. So that it triggers benefits.
It triggers it does the reverse where they might say there's a cap on the payroll percentage and then they change the benefits accordingly.
Yeah, so in other words, if the fund is losing money, they'll raise taxes until they hit that cap. If it's still losing money when they hit that cap, they'll cut benefits to preserve the solvency and return to the legislature. I don't know that they've done that, but it's a safety valve that they have built in. Other states or other proposals that I've seen have, if they allow for an automatic adjustment, if the adjustment goes outside of a certain range from year to year, it goes back to the legislature for a review of whether to adjust benefits or impose a waiting period or something like that, all of which are things that we've done with, we can't adjust UI benefits, but we have imposed a waiting period to preserve that fund in the past.
Okay. I thought we adjusted UI benefits back in the recession, but that was.
No, that's actually one of the things we can't do because the mainframe is so old. We risk the loss of the mainframe. So your colleagues down the hall have struggled with that issue. It's 250,000 lines of undocumented code in a coding language that was, that was becoming dated when my father was in high school. So give you an idea of what they're dealing with.
Or when I was in high school. Thanks, Danny.
No, no. I'm not gonna go there. I'm not guessing anyone's age at this table. So I know my father's age.
Okay.
So, but
Yes.
So, two questions for you. One, I was just looking for it, but don't see it. But I have a note about, how do self-employed folks transition into the program? I know it's a 3-year commitment.
so it's a 3-year commitment.
Is there that 15-month lead time?
So the way it's set up right now is they have to have paid in for 2 quarters before they're eligible for benefits. So there is not that 15-month lead time.
Is that, I'm sorry, is that just based on having income in the two quarters the year previous?
That they've paid contributions on, yeah, or taxes, however you want to phrase it. In either the 2018 or the 2020 version of this bill, or version of the PFMLI proposals that have come forward previously, there was a transition section that was worked out once the projections were in to figure out how to transition self-employed, or how to transition, trying to remember what that one, but it figured out the transition at the start and when people needed to start paying in if they wanted to elect to enroll rather than the folks who are in automatically. And so there was a specific date they had to enroll by and they had to pay contributions. So that would be a policy decision, whether you want to require more than 2 quarters of contributions from self-employed opt-in. Because it does, at least at that initial date, there's a difference between them and the employers.
And then on page 14, line 9 through 11, I have a comment. Ian had a suggestion.
Fast enough to make it what it was.
So my comment at that point was that the committee could consider just if you wanted the belts and suspenders approach, just noting that employees of an employer with an approved private plan are not liable for any contributions. I talked this over a bit with Abby offline, and her read was that it's pretty self-evident already that those employees are not liable because it's up to their employers to withhold and deduct the contribution from their payroll.
All right.
And so if the employers don't have to withhold and pay the contributions, it's implied that those employees don't. If you'd like the belt and suspenders approach, we can just say employees of an employer with an approved private plan are not liable for contributions
But
pursuant to this.
Because the employer has the responsibility to remit, then they're not.
Yeah. Yeah, so the implication is the employees are not liable. And presumably the employer would deal with premiums internally for their own program.
Right.
In the same way they might for another insurance policy that they carry.
Thank you.
Thank you. Found the answer to my first question. Second question, which I feel like we've covered before. The whole, I already know the answer. The whole single and self-employed person, that's purely just a political decision, there's no reason why. Obviously, because they can join.
Yeah.
So
Yeah.
it's just a choice in the bill to keep them out.
Yeah, so it's an opt-in is purely a policy decision.
Okay.
There have been versions of this before that didn't include an opt-in. And there, I believe, are a couple of states that don't have an opt-in.
Okay.
Although the majority of states do.
That's what I, for some reason, was jumbling that up.
Yep.
Damien, so the first 6 or 7 pages of text are definitions. And while there are some, there are some substantial changes to some definitions across the statutory universe, is there anything in there that, in your opinion, stands out that we need to just really, like, sometimes words glow off a page. And, there's changes in here, like the definition of employer is going to change in several years to being just anyone who has an employee, as opposed to what PFLA has now, which is 10 or 15. But are there any other words that stood out to you as you were doing this that we should be paying special attention to? Now, committee, we're going to be going through these. We're going to start with a relatively wide tooth comb and get down to a fine tooth comb over the next week. But I just wanted to ask Damien to see if there was anything that should give us pause, in your opinion, as you were putting this together.
Looking at these definitions, certainly you would want to look closely at, for example, the definition of family member to make sure it includes everyone you think should be in the bill and no one you think should not be in. That definition goes on for a page and a half, so it's quite detailed. That is worth a close look. It's not to say it should necessarily give you pause in a bad way, just it's worth looking at closely. The other definitions in here, just going through them, the qualifying exigency, it's not, the definition cross-references the Code of Federal Regulations. So it's a well-established definition for purposes of the Family and Medical Leave Act. But if you're curious about what that covers, that might be worth just looking at a little more closely. Let's see. The definition of safe leave is this is sort of a new program. So that's something that might be worth a closer look, because that's a new idea that's included in this bill. The self-employed individual, just one thing to note here is it's worth noting that it's someone who literally works for themselves and has no employees. So someone who owns their own business and has employees, if they wanted to be covered, would have to treat themselves as an employee under the way the bill's structured. If that's a concern, might warrant more of a look and more discussion. And then the serious illness or injury, we already talked about how looking at serious health condition, the definition under the federal law might be helpful to look at the differences between that and this because of some of the dated language in here, particularly the reference to a physician instead of a healthcare provider, which would encompass. So the serious health condition encompasses care scenarios that a wider variety of individuals in our current medical care system might have. Especially if your PCP or your treating healthcare professional is like an advanced nurse practitioner, or if you're a Christian Scientist, or if you have a physician's assistant, that's your treating healthcare provider. In all of those cases, this would actually prevent you from qualifying the way it's worded now. So that could be a potential issue.
Okay.
And that's worth a closer look.
So can I
Yep.
go back to the definition of self-employed individual?
Mm-hmm.
So there are three definitions there.
Yep.
And the last two require no other employees. The first one, if I'm a sole proprietor and I have 5 employees, I'm still self-employed, even
Yes.
if I have other employees.
Yeah, so that actually, that's a good point too. There's an internal difference there. This language actually dates back to questions that had come up about in relation to unemployment insurance and workers' compensation and who's an employee and who's a contractor over the years. So this comes out of, for those of you who have been in this building for long enough, the discussion of the employee classification and independent contractors. So that actually is a good point in there. If you're unincorporated and you have employees, technically you could still qualify as a sole proprietor or partner owner. But if once you've incorporated or formed an LLC, so basically once you've formed that sort of legal entity to operate your business through, you can no longer have employees under the way this is defined. So something that's worth looking at and talking about, whether you want to say no employees for everyone or whether it makes sense the way it is. I have talked to David Hall on this, and this does cover essentially all of the legal entities would fall within these terms or the sort of self-employment options. The question really comes around whether you want to permit them to have employees. You could say a sole proprietor, partner owner of an unincorporated business, member of an LLC, or shareholder of a corporation that does not treat themselves as an employee. But then you also get into issues of what if you have, someone who's bought stock in a corporation, they're technically a shareholder. Should they be allowed to enroll in the self-employed program? And that's a policy question. But you start to get into more complicated questions.
Yeah, I'm comfortable with this. I was just making sure I understood it.
Yeah. So.
Yes.
I was wondering, I apologize because I did not find before just now the definition of serious illness or injury. I wondered why it doesn't include rehabilitation from a serious injury.
That is a good question. It comes from our Parental and Family Leave Act, which predates FMLA by a year. I couldn't tell you why the definition was adopted the way it was, but that potentially highlights another issue because if you look back at that definition, safe leave provides coverage to recover from injuries. But the serious illness or injury, if I went the wrong way, I'm sorry.
Page 9.
It poses an imminent danger of death, requires inpatient care in a hospital or continuing in-home care under the direction of a physician. But you're right, if you're not in a hospital and you're not in home, for example, if you're in a rehabilitation facility.
Or if you need to go to rehab once a week because you have an injury the fact is that if you don't participate in your own rehabilitation, the chances of your becoming further injured are exponentially higher. So it doesn't make actual financial sense to not do it.
Yeah, I would have to look at the serious health condition definition from the federal statute to see if it covers rehabilitation. But it is a far more detailed definition, I think is the best way to put it.
Yeah.
And I can get that information for the committee for later this week as something for the committee to review.
So I have a question that's very different, I think, from I think we're talking a lot about the folks who will use it or may use it or may abuse it. What happens for the folks, so I guess this is similar to the question that was asked earlier. What happens if someone pays in but they don't use it? ever. So how does that balance out? What happens in those situations?
So there's, if you pay in and you never use it, you don't get your money back at some point. It's kind of like car insurance.
Right.
If you pay in and you never have an accident, you never get your windshield cracked, which I think is impossible in Vermont. Then you just keep paying into the program. So there are likely to be at least some individuals who either pay in and never use it or pay in for a very long time without using it. And there are likely to be others who, for whatever reason, end up using it more frequently because, they have greater needs that are covered by the program. So in the same way that you may have, health insurance or car insurance that you use very little or not at all, that could happen with this program.
And so in that same, I'm just trying to get the picture because this is very new to me, all of this language and all of these things. So with that, how does that play into the pool of funding that exists, right? So does that create some kind of surplus? Or like, what does that mean for the funding? Because I know a lot of this conversation is around funding and where is the money coming from and all of those things and where does it go, et cetera. And so what does that mean
Yes.
Sorry.
So the funding formula for this, just like another insurance program, is designed to basically it's designed so that everybody pays in one amount so that there's money there to cover the instances where someone needs basically a greater amount to come out and pay the benefits. So in the same way that I'm trying to think, with for example, workers' compensation is probably a good example because there we pool within industries. Health insurance, you pool across your health insurer, or if your insurer is self-insured, like the state of Vermont. State of Vermont has its pool of funding. A lot of employees need very little insurance in a given year. They go to their regular primary care appointment, maybe they get new glasses. And then some years though, they might have a serious health instance and there'll be a small number of employees every year who have very high healthcare bills, and the employees with lower bills essentially subsidize the costs for those employees. And then it shifts back and forth. So it's basically spreading the burden out across the pool, and then individuals who will need to take the benefit are able to get that benefit because the funding has been spread out across the pool. In this case, the formula specifically says projected benefits, administrative costs for the program, and then a 9-month addition, 9 months of additional projected benefits, just in case either benefits are much higher than projected or for some other reason there's a hit to the funding. So does that answer your question?
It does. I'm just trying to wrap my head around the language and the policy and just to see, just listening to the questions that people were proposing around coverage and how do we incorporate the language into the policy aspect. And I was just trying to have a better understanding of how can the safety networks that could be built in through language, per se, for those types of things. But thank you. That answered the question.
Sure. Yeah. And I'm happy to offline kind of break down, or if the committee wants to break down the difference in like what your annual contributions would be versus what your potential annual benefits would be.
Yeah. That's.
Yeah.
And so just last one, actually, just just one more thing, that's it, I promise. I know we're not the money, I know we're not the money people, so but just to help me wrap my brain around, because that plays into what happens here in my head. So is it, you said earlier, or someone said earlier, no matter how much you make, there's no cap at that on, like, I got lost in that conversation of like how much you pay. So is it a flat rate or is it different based off of?
Yeah, so it's, if you're an employee,
Yeah.
there's the bill says 0.58, but it's 0.55%.
Right.
Contribution rate, which is split between you and your employer. So you owe 0.275% on your wages, up to about $300,000 in wages. So very few Vermonters make that much. Some do make more than that, but most Vermonters will just owe 0.275% on their wages.
Okay, I remember that now.
Yeah.
Thank you.
So on that, Damien, bottom of page 11 states that the contributions for employees shall equal 0.58% of each employee's covered wages. So that's the total. And then on page 12, it's just a confusing sentence to me. And so, and again, maybe it's just me, but on line 5, in lieu of deducting and withholding the full amount of the employee's portion of the contribution, which, depending on what we choose to do on a policy decision, is either the 0.275 or forget 0.58, but if it's either the 0.275, or if the employee, if we decide, or in this process, if the employee is doing 0.55 and it's not being split with the employer. So in lieu of deducting and withholding the full amount of the employee's portion of the contribution, an employer may elect to pay some or all of the employee's portion of the contributions. So the sum or all.
Yes.
Like they're already based on this proposal, not on where we're gonna end up, they're expected to pay half.
Yes.
And they can always be more generous.
Yep.
Just, this sentence just seems a little awkward to me, because it's just in lieu of, they may pay something. I'm just, am I almost right in my interpretation anyway, or?
So what this basically allows the employer to do is, so the employer pays 50% right off the bat. This allows them to pay some or all of the remaining 50%. Is what it's intended to do. And I agree, it's maybe not a model of clarity. But what this basically allows is, if an employer wants to position themselves as providing a better benefit in this area, they have the option of saying, and as part of your employment package, I'll cover your family and medical leave contributions. So, or I'll cover the first, contributions on the first $20,000 of income, or whatever it is.
So to get going kind of with Representative Bartley's question before, I'm not saying that she was saying this, but if an employee, or if an employer wants to go over and above what this offers, again, the state program, what we're working on is wage replacement and job protection through this 12-week period. This is all we're guaranteeing for job protection. But an employer may offer and may offer a separate plan, might, the AFLAC of paid family leave might offer for a few dollars more, you can get this program. It's not so much the gold, silver, and bronze, but it's that idea that they can always offer more. And I mean, that's kind of what, again, with the years of reading this stuff, that's kind of what I saw in that too, is that reminder that they can always pay, you can always perhaps, no, you can't always, but you may be able to work for employers who are more generous than what the state is putting out.
Yes, so the employer can do that in two ways under the bill. Well, three ways really. So the first is this option. They can pick up some of your, basically some of the contributions that would be coming out of your paycheck. The second option is that they can purchase an insurance plan that's more generous for their employees. Maybe it provides wage replacement up to a higher level. Maybe they provide supplemental wage replacement for employees whose wages aren't getting fully covered. The third thing they can do is they can offer extended job protection through a contract. So that's something the job protection is a floor. Employers can always go above and beyond that. But that's, in all of these instances, it's up to the employer and their finances and whatever their realities are. Some employers may be able to afford to provide a platinum insurance policy.
But they would be buying that that's the one that they would be buying from a different.
Right.
The supplementary part of it would be purchased. We can't use this system and say, we're gonna pay more in this system for a higher benefit. They would have to purchase a separate.
Yes. Yeah. So if they decided to purchase a policy, some employers could say, we're going to do this platinum policy because it's a recruiting tool, or we're going to offer it to they have to offer it to all their employees, which is another piece here. They can't pick and choose under the way the bill's written. It requires them to offer the policy to cover all their employees under the policy. That's another policy decision, if you'll forgive me for using that word too many times. But you could always decide to let employers split out their workforce. But the bottom line is they can be more generous if they choose to do so, and it works for their business.
Right. So to beat it, of course, a little bit, but the idea that 100% wage replacement ends at $52,000 a year, whatever the average wage is. Mm-hmm. If I make $100,000 a year, I'm only going to see 50% essentially wage replacement. If I'm making that and I'm trying to use this program, I'm only going to see a 50% wage replacement. But the employer can turn around and say, here's the supplementary program that covers that 50% declining percentage to get back to 100%. That's all. I think I'm just repeating what we said. Representative James.
Yeah, I think it went away. I think we're good. I'm good.
You sure?
Mm-hmm. Yep. Yes.
You want to think for a second?
No, it may come back.
Representative Krasna, then Justin.
Okay, so I know that in this role, sometimes we think about the what ifs, right? And then when you started talking, I was thinking, and maybe this is impossible, but I don't really know as much about insurance companies as maybe I should. Is there ever a possibility that some large insurance company would swoop in and try to undercut and get a bunch of companies and employers to go with them, and then it would affect the state program? Like the way an insurance company would kind of swoop in and try to, I don't know, is that a thing?
Theoretically, yeah, it's possible. If an insurance company could offer the equal or better benefits and coverage, they could try to undercut the state, and then the state would need to revisit the solvency and viability of its program. At that point, I think I can't speak to how likely that is.
Sure.
But if that's a question the committee has, there are a number of states where they do allow employers to buy private plans, and you could look at the experience in those states. So I don't know what information is out there, but that might be something that some of the advocates know more about, or can put you in touch with someone from one of those states that could talk about the options that are out there. So.
Representative Chestnut Tangible.
Damien, I want to go back to the phrase that jumped out at me when I first read through this.
Mm-hmm.
It's on page 7,
Okay.
2 and 3. Qualified individual as a significant personal bond that is or is like a family relationship.
Yes.
And that troubles me. Does that phrasing have any kind of track record or standing?
That phrasing is utilized in Colorado in their definition of family member. It essentially boils down to the individual's chosen family. This bill does include rulemaking later on specifically on that issue to talk about what the standard is going to be. But yeah, it does not, beyond the language here and the rulemaking within the bill itself, there isn't, not like domestic partner or something like that, where we have some specific guidelines around and language in the statute. I'm not familiar with this being anywhere else in Vermont law. I'm familiar with it being in one other state's law. I don't know if other states have, beyond Colorado, have similar language.
That just jumped out at me as a potentially vague, therefore troublesome area.
And you could certainly, I mean, if you choose not to keep it the way it is, you can either define it further or refine the language so it's either narrower or so that you go with something like in loco parentis, which is a well-defined and understood term. And it's also in there. So this was not in lieu of in loco parentis language. This is to cover, oh God. It's been a long day, guys. When I start using a lot of Latin, it's not, especially since there's about 3 Latin phrases I understand. Yeah, it doesn't replace it. It's a supplement to the other language that was in there to cover that idea of chosen family.
So it's different from a domestic partner. Would Colorado law have gone through rulemaking to provide a more specific, I'm wondering if Colorado has they must have defined it.
Let me see what stage they're at. Because.
And actually, Davey, just, unless it's readily available,
Yeah.
I want to finish up this conversation in 2 minutes.
Okay, I will find out.
TY.
There you go. All right.
And no offense, but we didn't take a break at 3, and so I just wanted to finish by 4. Taking a break now, then at 3:50, and go. Is that fair? Don't go off yet. So, thank you. We'll see you all week at some point here and there. And so committee, our plan tomorrow is to hear from witnesses. We're gonna take some free time to, thank you. We're going to hear from Central Vermont, from the Vermont Chamber and from Carrie Brown, who was here last week, but was ill and didn't feel like she could testify. The Vermont Retail Grocers Association will be here in the morning. Then we'll pick up on a very similar conversation at 11:15 till lunchtime. And then we do have, after lunch, we have a witness who's going to talk about fraud. Fraud came up, and we're going to hear from her. And then on Thursday morning, we're also going to hear from Cameron Wood from the Department of Labor, again, just to talk about fraud in government programs. I mean, there's not a lot of programs that are out there that are like this, but, anyway. I'm sorry, you need a jar?
Where's the jar?
So tomorrow.
Oh, wait a minute. Come on.
But with that, the last thing I just wanted to say was it Friday, Ron?
Yes.
So Friday afternoon, we found ourselves at a point in the conversation where Joe had left, Ashley had left, and then Larry had stepped out for a phone call. And I'm really uncomfortable in continuing meetings when we don't have, when a full party's missing. Because we still have a quorum, but I don't think it's, I'm just really sensitive to having a closed door with only one party behind it. It's not anything to change anybody's behavior, but just know that if that circumstance happens again or anything like it where we're out of quorum, I'm gonna stop the live feed so that even though, I mean, I could make an argument that says, well, everything's recorded and you could go back and find out what we did or said. I think out of respect for just the process itself, I'm going to stop the phone call or the recording until we get back. And that's, again, that's as if a phone call comes in, it's fine, you know, that people have to respond in that way. I just want to make sure that we know as a policy that I hold dear is just to try to make sure that we're operating in a transparent manner. It's nothing major, but I just felt that's one of those things I just needed to say so that we don't have a misunderstanding about that.
Well, thank you for that. Probably a good policy, but it's on me if I leave. So I just don't ever feel like if you've got 20 minutes left in a day that you can't just, I can speak for myself, but I was watching on YouTube.
Yeah, no, I thank you for that. I just, in this world of Zoom and YouTube, you know, again, I can make that excuse very easily and just say, well, you know, whatever, but I just want to be really sensitive to how available we are. And the flip side would be somebody calling in and saying, hey, there were only Democrats in that room. And they were, you know, and so I'll leave it at that, but thank you. And we'll just handle it as it's all new. There's all new rules that come, not rules, but just there's new situations that pop up all the time. And that was the first time that it actually happened where I was in a committee hearing with no R's and P's in the room with us. And it was a little spooky actually, because it's just not usual. So while we're in the middle of a hearing, so.
Can I?
Yeah.
Earlier, I think it was you, Chair Stevens, who brought it up when the treasurer was here about what happens if the state goes into a contract with the plan the administration wants to put forward and this bill comes out. How do we do that? Like, what happens then? So reaching out that apparently we are under contract now.
Want me to talk about this?
So I was just wondering.
You can do it in less than 4 minutes, or we can talk about it tomorrow.
I was just saying that maybe bring somebody in from the administration to talk about it, because maybe they've already had this.
So it'd be good to have a side-by-side comparison, if they indeed.
Of their plan versus of this plan here.
Right.
Yeah.
Or at least what would happen in that case if they've already thought it through.
So I can tell you that the latest update I got earlier this week is that they're still negotiating the language of the contract. So, but that they'll be providing copies to some of the legislative offices that have leadership that's requested it when the contract is available after proprietary business information is redacted and that sort of thing. We could certainly have them come in. That's up to the committee. and they can talk about the program and the process. The biggest consideration, just from my lawyer hat, is just the timeline on the contract. And I think the treasurer mentioned this earlier. Is there an exit clause? What's the term of the contract? For example, if your contract is up on July 1, 2026, for example, and the program starts on October 1, 2026, there's no problem. The potential issue you get into is if the state is under contract and there's no exit clause for the contract, and the state has financial obligations to the entity it's contracted with, the state cannot legislatively renege on its financial obligations. So absent meeting extremely stringent guidelines that the Supreme Court has set out, which we are unlikely to be able to meet in this circumstances. I mean, it's essentially like a financial emergency is required and there's no other option. Before you even get to those questions, the questions are, what's the term of the contract? Is there a renewal period? Is there an exit clause? And then, of course, there are the other policy questions. What does it look like side by side, et cetera? So those would be the questions for the administration when the contract's available.
Yeah, from the way I read it, it sounds like there's a contract. Maybe I was overstated, or maybe I read it wrong, but it sounded like.
I think there's an agreement in principle, and they're hammering out the details with the attorneys right now, is my understanding. So that I could be wrong. It'd be worth getting them in.
We'll talk about it during scheduling tomorrow. And we'll definitely, I think there's an idea that we couldn't get through this process without hearing from the administration. I just wanted to make sure that our work was, yes, we could compare them or contrast them, but they're not technically in competition with each other, at least through this process. Can I request, just as we go, can I request a section by section?
When do you want that?
I think by next Tuesday.
Okay. That I can definitely do.
I want to, again, Damien's got all of our, not ours, but building points still up to, so.
Yeah.